Good afternoon, everyone. Welcome to today's session on animation, fashion, and music law. We are having a conversation today with Liz Lenjo. That's Shori for IP. So karibuni sana. A few ground rules before we begin. Any questions you have should be directed to the Q&A. Please don't put questions in the chat. It will be a bit difficult to manage when we are now working to look at the things we need to respond to. I have with me also Salome Asena and of course John Sunday. Wave to the people and say hello. Yeah, so without much further ado, I will get started. It's a conversation. So we want to start off by Liz talking to us about common definitions in IP, a couple that she can pick out, say on patents. What is a patent? What's the difference between a patent and a trademark? What is Creative Commons? You know, these terms that are bandied around, people don't quite understand. So I'll hand over to you, Liz. Thank you.
All right. Hi, everyone. Thank you, Helen and team, for having me and for inviting me. So, of course, when we're talking about IP, I think the first conversation is always about definitions. So I'll try to summarize and then we'll discuss them further as we discuss the different topics that we have today. So first things first, whenever people hear about IP, they're always told, or they will say, I want to patent my idea, right? We don't patent ideas, we protect the expression of ideas. Patenting is one of the form of protections of these expressions of ideas. So under intellectual property law, we have different regimes of protection. We have, they have been bundled into two. We have industrial property and we have copyright. So under industrial property is where we'll have the patents, we have utility models, we have trademarks, and we have industrial design. That would fall under that, which we'll discuss shortly, and then we have copyright. So patent is the highest form of protection that is granted to any expression of idea. And this cuts to mostly scientific, technical type of innovations, and they have to be novel, new, and industrially applicable. So novelty and newness basically means it has never been done before or has never been published before, never been seen. So what this means is that even you as an innovator, you can easily destroy your novelty by just publishing it online or somewhere. The minute you create something that is patentable, you must run to the register first before you put it anywhere else. Otherwise, you destroy your novelty. Like I said, it's never been done before, so that threshold is really high. You know, you get 20 years of exclusive protection and exclusive rights, which means no one can do anything with that innovation or even aspects of that innovation without your permission. But they have to be the innovations that, the innovations that you have protected. We call them claims in patent language. With patents, again, we have to go through a stage that involves the publication, which means that people now will know what you have innovated. So again, with that, it comes with its own challenges because it can easily be reverse engineered. And that's why you hear the common word trade secrets being put across, because that's another alternative to patenting. Again, it would depend with your business strategy. So with trade secrets, it's more about the contracts that you will sign between your employees and the people who work with you or for you to make sure that they keep this information a secret. I think one of the companies that we can use as a great example that has used trade secrets successfully is Coca-Cola, because to date, we do not know what Coca-Cola entails. And the kind of contracts Coca-Cola employees sign is not a joke, for sure. So if you want to do the trade secret route, then that means you'll really invest heavily on contracts. Then we have utility models. In American lingua, they call them petty patents, which are improvements to the patents. So which means that if I create a utility model to an already existing patent, the law does not prohibit you from doing that, but it prohibits you from commercializing as long as my rights as the patent holder are still valid, which means those 20 years of my exclusive rights are still alive. And then, yeah, so then you get 10 years exclusive rights over this utility model. So as long as the rights subsist, you will always be sharing with the patent rights holder. In the event that the patent has already, gone into what we call the public domain, because the 20 years have lapsed, have expired, then you don't need to pay anyone, all right? Again, you have to be very honest about the utility model and the fact that you're not the pioneer and that you're just merely improving. Because if you do that, again, you'll also waste a lot of time and money trying to claim a patent where you can't. Then we have industrial designs. Industrial designs protect the aesthetics of what we create. So like if you're in the furniture business, you're in fashion, if you're in, I don't know, interior design, if you design appliances or whatever it is, the aesthetics are what are protected by industrial designs. So which includes the colors, the shapes, the combination of lines, the textures, all those elements, aesthetically pleasing elements are what are protected by industrial designs. And they're protected up to 15 years. So 5 years, 5 years, 5 years each, up to 3 times. And then after which they revert into the public domain. However, there could be strategies to help, make that life longer, depending on the kind of business you're in and your plan and desire for these designs that you have created. And then lastly, we have trademarks. Trademarks protect the names that we use in our businesses, the brands that we create. So the use of names, logos, shapes, numbers, combination of words, the slogans, all those are protected under trademark. However, for you to be to get a trademark right, it has to be what's the word? It should not be descriptive, and it should be uniquely used or applied for you to get that protection. So, for example, like my laptop, Apple. Of course, Apple has nothing to do with the laptop, but it's creatively used. So the name Apple plus the logo of how they do the Apple logo, those are protected as a trademark for them. And then with trademarks, you have what we call classes, which deal with the area of business that you're in. So we have the nice classification divided into goods and services. So if I'm a fashion designer, I'll fall more under goods because maybe I create clothes or shoes or whatever. If I'm in the computer business, like say Apple, for example, the Apple logo is protected under electronic devices as one of the classes in goods. Yeah, such like. And trademarks are protected for 10 years. And are renewed every 10 years. So you could decide to abandon after 10 years, or you continue renewing until such a time, you decide you're bored with it. A good example of one of those very old trademarks would be Toblerone, the chocolate, would be Mickey Mouse, for those who love animation and such like. And then we have copyright. Copyright protects now literally the expression of ideas. And it cuts across literary works, artistic works, sculptures, software, sound recordings, broadcasts, audiovisual works, paintings. So all that is usually underlined under Section 2 of the Copyright Act. So all those artistic things that you interact with, also architecture. Architects, I don't think they use much of copyright yet, but it's something that protects their works. Copyright is valid for the life of the author plus 50 years after death. However, it will depend on the type of work in question as well. So with the exception of photographs are protected for 50 years from the date they were published or captured. So for those 50 years, so they're not pegged on the life of the author. And broadcasts as well actually for broadcast, they must have been broadcasted. So photography doesn't have to have been, published, made in public, but as long as it has been taken and you decide to put it in your drawer, the 50 years start running from the day you clicked the shutter. For broadcast, it's 50 years from the day it's been broadcasted or made available. Same thing with audiovisual works, recordings / movies or films. That's how the time runs for them. Yeah, so I think that would be the definitions. There are other types of IP we've not talked about. For example, traditional knowledge and cultural expressions, which we recently passed, okay, not so recent, 2016, but now these are community rights. which means that any cultural property that you use that can be attributed to a community, you must attribute that community, and you must find a way to compensate that community. And also you have to have their permission first before you go to the market with any of these TK or TCE related influence in your products. And then we also have plant breeder rights. If you're in agriculture and you decide to create different plant varieties, you want a drought resistant, I don't know, flower or maize or whatever the case may be, you keep breeding all these plants, and you, as a result, once they meet the threshold of plant variety, then you get that right over the plant variety that you create. And then, unfortunately for us, we don't have geographical indications, but that is something that's also part of intellectual property, and it protects products based on the geographical area they are from. So, for example, champagne is called champagne because it's from the area of Champagne, and many others that are there. So those would be the definitions. And then I think you mentioned Creative Commons. So Creative Commons is complementary tool to copyright. Creative Commons exists as a mechanism to help sort of build the body of knowledge, because knowledge is viewed as a public good. And what Creative Commons does is helps authors who want to share their work without much complexity to be able to do so, while still being able to earn and contribute to the body of knowledge. When you go online and you go into Google and search Creative Commons license, you will see those different signs that are there. So they help you decide which kind of license that you want. Do you want your work to just be shared alike? Do you want to be credited or attributed? Do you want to make sure that nobody uses it for monetary gain? You know, that dollar sign and an axe. And then the other sign I have forgotten. So, but basically it's that combination. But Creative Commons just helps an author to share their works within a certain way of control. And based on the Creative Commons license, you're able to say, I want to share alike. So for example, like I'm a blogger, if I want to hyperlink some of Helen's work, for example, I have to go to her site and look at her Creative Commons license and see what does she say? Does she say share alike? She wants to be credited, then I hyperlink it on my website, and I'll also say borrowed from Helen's article on blah, 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 and I hyperlink. And that confirms that I have used it the way you would like to be used, and there's no infringement. So that's what Creative Commons does. And it really benefits authors and creators to also be known, because the more people have access to your work, they know your capabilities, and it could subsequently lead to more work. So it's really underutilized, unfortunately, by Africans, but it's something that we can really benefit from. Yeah.
Okay. Thank you, Liz. Before I take you back to, there's something you said on traditional knowledge and cultural expressions. What is copyleft?
I think copyleft is just one of those words people just coined when those people who are, I don't know, should I say anti, I don't know, ownership. I think for the longest time, people used to feel like IP is all about just mine, you know? And we have seen over time, people realize that the more we are too closed up on ownership, the less we make the society better, the less innovators also get to re-innovate and make life better and give more, creative solutions. I think that's how they ended up coining that time copyleft. But it just simply means that ability to share your work without strings or whatever. So, but it's something that also at some point people would use it synonymously when they would refer to Creative Commons. But thankfully we've sort of dropped using that word, because I feel like it just connotes negativity. And yet at the end of the day, we must incentivize creatives or inventors or innovators so that they continue innovating and making life better and more interesting and easier, at the same time contributing to the community. So it's something that goes hand in hand. And even without the Creative Commons, it still does that. Although like for copyright, it might take slightly longer because there's that 50 years after death, right? We're going to wait for 50 years. So thank goodness Creative Commons came. But in the other IP regimes, as you had me describe, there's the 20 years for a patent, after that, public domain, 10 years for the industrial design, for the utility model, back into the public domain, 15 years for the, for the industrial designs, and then for the trademarks every 10 years. until I decide to abandon. So you can see already even the IP system itself gives back to the community. Yeah.
Okay. Okay. So I wanted to take you back to traditional knowledge and cultural expressions. And perhaps you could delve deeper into appropriation, this thing we keep hearing about, cultural appropriation, and juxtapose it with appreciation.
That just takes me back to my paper.
Yeah, and then give us examples of, so what is this cultural, what's this traditional knowledge and cultural expression that is protected? Is it how I dance, the kind of sisal skirt I may wear, a head wrap? So, you know, what is it?
All right, so let's start with what is TK and TCEs. These are basically the properties that identify with a certain community. They include the way of dressing, they include the language, they include some of those traditional practices, the costumes, the foods that they enjoy and whatnot, the rituals that they practice, to an extent, even like if they have like certain writings or stylistic ways of writing, for example. So anything that can be attributed to a community is protected by TK and
like
TCE.
jollof rice, for instance.
Yeah, so like jollof rice would be a cultural property. There's a knowledge aspect of it, how they cook it, and then there's the presentation of it and whatnot. Yeah, so that's TK in a nutshell, what is protected. So this is a relatively new addition to the body of IP that is still developing. However, the basic ethos is that communities have moral rights, just like in copyright, that they have in their properties. There's that moral rights that they have, that there's a certain way that their works can be used or their properties will be used, and to an extent could be derogatory, which means then you have to have permission. You have to seek permission before you use these works, so that you respect their rights. At the same time as well, you have to also compensate them as you use their property, because it didn't come from nowhere, it came from somewhere, right? So even the minute now you take this work and mix it or this traditional expression or cultural knowledge, you mix it with something else and create something new, you have to compensate the particular community. So for example, if I decided to package mursik and I make it mursik the way the Kalenjins make it, then I would have to compensate the Kalenjin community. The challenge right now we have with TK and TCEs are two. One, documentation. Communities are yet to document the various TKs and TCEs, so that then we know. Again, when you look in the context of the TK Act, we're talking about counties. But remember now with the counties, there are certain communities that can be found in like 3 or 4 counties, right? So yes. Again, the issue of compensation needs to be tackled, so that then as a business person, if I make this mursik, I know which counties, because there are several counties that have these communities that are there. And then remember, again, when we're talking about communities, especially like in the context of some of these Kenyan communities, for example, I think the Kalenjins have like sub-tribes, the Mijikenda have sub-tribes. So already there are those issues that we need to discuss, and hopefully the regulations may tackle that to understand further. Counties need to have a conversation. But yeah, that's basically what TK means. So at the end of the day right now, if you end up using it, your best bet would be through the Ministry of Sports, Arts and Culture, as the regulations are being figured out, because I don't think it would be fair for us to say we'll wait for the regulation and then it takes us another, I don't know how many years. Already, we've been waiting since 2016. So I think that's one of the things that how the act is drafted, we could use the ministry for now as the regulations are being ironed out. So, but that's TK and TCE in a nutshell. Again, with TKs and TCEs, the compensation for communities doesn't have to be monetary. It can be also in kind. So, but that's subject to negotiations as well. So again, with TK and TCEs, we still have a lot of streamlining to do because of the absence of that documentation, because that documentation will help us also identify that sort of execution and streamlining the different counties and the communities who can who would be the focal point when it comes to clearing some of these rights. That's yet to be tackled. Yeah.
So this is quite interesting. So you compensate the community. So you'd have to negotiate like with their
council
chiefs.
of elders or something, depending on how they're organized.
Wow.
Yeah. So again, you imagine the issue of modernization and the fact that some of these communities may not still have them. I think the exception of the Maasai maybe, but even them, remember they are in different areas of, should I say, Maasai land, for lack of a better term. So like, because if you look at the Mara, the Mara is so vast, and their counties are very vast. So you'll find that each corner there's a council of elders on that side, another on this side, another on that side, And then remember, we have Maasai in Tanzania as well. So I think TKTCEs, there's a lot of conversation we need to have around that.
Okay. I want us to talk a little bit about fashion, but the ethics around fashion when it comes to IP. You talked about industrial designs, fashion, colors, shapes, combination of lines. So looking just generally at our fashion industry in Kenya, how would you describe the advancements in terms of those creatives understanding that they need to protect their IP?
Okay, so I think we start with the fact that I think I can say, unfortunately for us, because we do not produce our own textiles, it becomes very difficult. Unless like you're in the printing sector. You remember back in the day when we would do the batiks and the tie and dyes. When I do that and I do something new or different, then it would qualify for industrial design protection, right? So in the absence of that, or in the absence of creating something that looks different or feels different in terms of textures for the textiles and maybe even garments, then you find that we are now just renovating in the space of already existing stuff. Like you just take a piece of fabric and I just change how it looks. So again, in fashion, and IP can never protect the shape of a dress. A dress is a dress, right? Unless there's something huge that you've done with it that people have never seen before. But the way the dress looks like, it's generally standard. It's the A-line, it's the straight, exactly. If it's a trouser, it's a trouser. If it's a short, it's a short. The only thing that will change maybe is the pleats. Yeah. So with that in mind now, there are certain things that you could use to make your outfits different. I'll give an example, like Levi jeans. Levi jeans are Levi because of that pocket, the design of the pocket on the behind. Yeah. There's a specific way they have done the pocket, and that is what they have claimed and protected it. And for them, they protected it actually as a trademark because it's a long-term thing. Remember, industrial design is 15 years, so it's really more of short-term, right? So them, they took the trademark route. It was granted by the USPTO, and they've protected themselves in the different countries where they have commercial interests. So again, something I forgot to mention is that IP is territorial. So by virtue of protecting in Kenya, I'm not protected in Uganda. I have to go and register in Uganda as well. Yeah. So like, for example, Levi's, that's one of the things that they've done, the pocket behind, and then of course the brand that they created, Levi's, the name. So that's the kind of protection that fashion designers in Kenya should look at. So which means as well, if I'm creating, if I do menswear, what is that thing that sets my designs aside, right? Such that even the consumer will know that these are clothes by Liz and not by Helen. Yeah. So I think it's just that understanding that if you didn't create the fabric from scratch, then it will be more of a branding game, and how you assert your uniqueness in the market.
So I can say that Liz has copied the design of my jacket, and therefore she has, infringed on my IP. So how do these fashion designers, Karl Lagerfeld, Givenchy, how do they make sure that, those designs they roll out like every spring edition, those are not protected at all?
they have those elements that they protect for sure, depending on their different strategies. Excuse me. And then remember, if you look at these high-end designers, they have, if you look at the kind of strategies that they have, they're very different. They'll have the high-end lines, and then they'll have the common, or rather the fast fashion products, right? So of course, the high-end lines, there'd be a strategy, because by the time I'm creating a collection as a designer, I have a strategy, right? I maybe I'm thinking of some wedding season or something. So even for them, even their marketing strategy, they're very quick to make sure that they make their money and they onto the next collection kind of thing. So they have certain strategies also on their back end, and then definitely they will protect them. So aside from just the name of the brand, if there's a new print, they do these things before they go to the fashion shows. They'll do those protections. If it's a new print that they've created, it's a new line that they've created and they've named it a certain way, they will quickly go and register the trademark and do all these things, because registration is what you have to do first before you go into the market. Because that's how you will assert your ownership, your novelty, and the fact that you came up with this work, right? So that's what they do. Something else that they do also, they're very strategic with their markets. They know where they make more money. So like now, I'm sure we can note that we don't have much presence of some of these high-end designs in Africa, but they're there in Europe and the US and Asia because of so many other reasons. The high net individuals live there. The people who appreciate fashion are more, they live there more than they live here. So you find that here we are like more of an afterthought. We if they are here, they are more through like third-party licenses, either from Asia or from Dubai, which is actually one of those countries that have that give rights for them to put their works or their products into the Kenyan market. So yeah, it's all about strategy at the end of the day. Yeah, and now these designers are coming into Africa. We are seeing, I think Chanel is going to be doing its first fashion show in Africa, in Abidjan. So now they're now coming here as well, because there's a market, and we have seen a lot of counterfeit goods in fashion here. You go to a shop somewhere on Dubois Street and you're told, oh, these are Calvin Klein, then you know for sure they're not Calvin Klein for 2,000 Kenya shillings. or Givenchy, you're told, this is a Givenchy bag for 2,500, So I think they're also slowly realizing that there's a market in Africa, and eventually they'll also figure out how to collaborate with African designers.
Okay. This fashion arena, I have to stay there a little bit because it's relatively newer. A reminder from John that we are live on Facebook. And if you could tweet so that we can trend, hashtag USIU Law 2022. Yeah, and you tag Liz and I and Salome and USIU also in the process. Yeah, so fashion, perfumes, IP within the realm of perfumes. Yeah. And I want to specifically, I won't mention the brand, but there's this brand that is borrowing a lot from the Arabic or Asian influence. So you'll find a lot of oud in their scent, the fragrance. So do they have to compensate those communities? And then how do you protect this scent and say this scent is uniquely Liz, or this scent is uniquely Helen? And so if you go and produce something with the same, scent, then I can say, okay, you have now squarely gone into the realm of infringing on my rights.
All right, so let's start with how scents are protected. They can be protected in the developed countries like Europe, in the EU. They have under the Trademarks Act or their Trademarks Act, they have what we call olfactory marks, which refers to the scent or the smell. Again, it's a very intricate process, but that's doable. But there's of course a science to it for you to be able to ascertain and say this specific scent is mine. Now, moving to that whole oud conversation and the Arabic conversation, again, I think to be subject to that sort of threshold. Because remember, these scents are a combination of natural elements. Yeah. So, I can't comment with conclusivity here because, for us, olfactory marks are relatively new situation. Actually, we don't have them at all, right? So, but in what we have seen in case law and just legal conversations, it would come down to how they ascertained that olfactory mark is different, is new, is fresh, and it can be pointed to a certain person or brand. Yeah, so it would be subjected to that kind of science. So again, with documentation, again, if say a certain Arabic community was able to effectively document that, then at least you can show that they have taken this from this community and borrowed and put it to market without their permission.
Okay. What about before I get to Francisca's questions, because I want us to exhaust fashion, then now we move to the next because the topics are really broad today. I hope we'll be able to do justice to them. So hairstyles, African, what we call African hairstyles. How do you protect those?
That's
if they're
another
even
one.
able to be protected.
I know, right? We've yet to see like any conversations or issues around that. I think the most conversation we've had around hairstyles or cornrows has been, in the context of the US, and there was a time when the Black Americans would be like, oh, this is cultural appropriation. Why is a white person, preparing or making cornrows? But again, I think there's a lot of should I say sociological type of research that needs to also happen, because I don't think it's only Africans who had cornrows. Even with the Native Americans, for example, those native tribes in Europe, I'm sure even for them at some point they would have such things. Remember the story of Rapunzel, and she would, braid her hair into a rope and throw it down. So I think with hairstyles, it's generally fluid, and I think if we tried to really assert IP on hairstyles, I think it would be problematic, right? Like how am I paying a license every time I make my hair? or when the hairdresser is making my hair? It would just be interesting. However, though, there are other affiliates of IP that are created when it comes to the hair care industry. If from the products that are created, so if it's I want to do shea butter, of course shea butter can be protected, it's a natural whatever. So, but I could have Liz's shea and Helen's shea. They become two separate brands, right? And then it's just how I market it that I stand out and I can compete with you and take away your clients, for example. There'd be hair processes that are involved, that are there. So we've seen over time different hair processes, from the relaxing to, there's one I have forgotten because it's banned in a couple of countries. It has to do something to do with keratin. It's another process where you coat your hair with keratin, especially African hair, and it can retain a blow dry for like 3 months. So there are certain of those, some of which come, of course, with caveats, because the chemistry also behind it can be harmful to people. So I always tell women, when you're going to make your hair and when you discover some new technology, please read about it first before you go and do something on your head. And then, either you lose your hair for life or it affects your lungs because there's those fumes that come in contact with us, like all those things. Always do your homework, right? Hopefully, eventually, we'll also have KEBS do more when it comes to the hair care industry in terms of some of these processes as well, and the products arising from some of these processes. So with hair care, there would be all those other affiliates. There'll be the accessories that you create. I decided to make a nice, interesting fascinator that can be protected either as a trademark or as an industrial design, depending on the strategy. If it's even ornaments, the earrings, the necklaces, that now would be about how different you are. So it would never be at you're the only person creating earrings from brass. Brass is a common element. So it's about the house. It would be about the designs that you create as well. Again, when we're talking about hair, I think in the context of what we see nowadays with Kenyan salons, is I go to a salon, they make my hair, and then they take my picture. So in that conversation now, it becomes more of an image rights conversation and the balance with copyright. Yeah. So as the hairdresser, I'm holding the camera, I take a picture of you. I have copyright to the picture. However, the copyrights cannot exist by themselves, because I have to factor in Helen's rights, her right to her image, her right to her reputation. Does Helen want to be associated with my brand? Does Helen even want to tell the whole world that she comes to make her hair into my space? Because again, there's privacy issues in that regard, because the minute I start taking your picture anywhere you go, I'm infringing on your privacy, right? So again, for those of us who go to the salon, make that conscious decision that either you want your picture taken, or when you see a camera being rolled out, you're like, no, please, I do not want my picture to be taken. Do not put me there. And if you took someone's picture and put it on your IG or on your Facebook to market your products, and they tell you to take it down, they have a right to ask you to take it down, because even them, their right is protected under the Constitution. They have reputation rights and they need to be protected. So you have to actually heed to their request. So if you want to do that, have some release form in your salon and say, okay, Liz has come to make my hair. Can I give her a form? It's a simple form, just saying, I, Helen, accept to give Liz the right to put up a picture of me on her Instagram to market her services. And then, of course, even me, I want to be smart and say, okay, you want to use my picture? Okay, see, then every time I come, you give me a 10% off. It's a negotiation, right? Yeah, but I think that's what I would say when it comes to hair and IP.
Okay, thank you. And you talked about, I was going to ask you about jewelry, but you've already talked about that. So I think we've gotten at least an understanding of this genre of fashion law. Francisca has a question. Does a member of a specific community who uses cultural designs from their own community have to compensate the community? That's the first question. And then there's another question again from her, whether a community has to be compensated for language use. So for example, if she calls her company Utamaduni Arts, who would she compensate? We'll
Those
get
are very
to this.
valid questions.
Yes.
So we can start with those two, Cindy.
Yes.
So the first one, does a member of a specific community who uses cultural design from our own community have to compensate? Yes, in my understanding, because remember, you are not just the community, there's other community members. So as you derive some sort of profit or benefits from it, so should the community members also benefit. So regulations are being drafted at the moment that would hopefully tackle that. So the minute you hear that the regulations are out, please show up, please make a point of knowing what they are and be part of the public discussion, public participation, and make sure you have your voices heard. Because remember, again, we have been operating in a context of some of these things are communal in terms of if I had access, I could still use it. We did this, for those of us who did the old 844 curriculum, there are certain aspects of even traditional knowledge and cultural expressions that were there in art and craft and music, right? So we got this knowledge. We got the knowledge how to make anyatiti. So if they decided to make anyatiti, things like that. So there's some conversation that need to happen there, but at the end of the day, if you're going to use work from, like, for example, if I decided to do tighter baskets, and I'm calling them tighter baskets, and I'm using the knowledge that the titers have, I have to share some of it with them, right? I have to go even seek their permission to begin with, and then actively and legitimately commercialize. When it comes to the second question around language, if you ask me, when it comes to language, I think there we erred. That was a big error in terms of asserting TK and TCE rights over language. And the reason I say this is because when we are creating brands, we heavily rely on language. If we look at just the Kenyan context as an example, most of our businesses have either English words, right? So if we start having a conversation around asserting these rights over English words, English is actually derived from the German language. So then we start paying the Germans, yeah, and whoever else might be involved. Kiswahili, we have Arabic influence, and then over time we have seen, like, the Kenyan Kiswahili will also have some words that have borrowed from other languages and something. Like it's just this whole huge thing when it comes to language. So in that regard, I feel language should have been the something that we kept aside and said, let's share. Unless now we're talking about the expression themselves and say, okay, and then we're also restrictive and say, because like sacred names like God in a certain language, that is something that's sacred, please don't use that, or, but again, if you examine language, actually it's so complicated. There's some words, let's not even go far. Look at what's her name, our tennis champions media station that she just launched 2-3 days ago. Her name has disappeared.
Naomi Osaka.
Yes, Naomi Osaka's station. In Japanese language, it's a beautiful phrase. In Kiswahili, on the other hand, it's a problem. Yeah. So you see why I'm saying at the end of the day, when it comes to TK and TCN language, I think that is where we should have just made some concessions, to be honest. Maybe hopefully we will, as we do the documentation and realize that there's some things we can't really over assert. There's some words we'll use in Swahili, in Zulu, they mean something else. In another language, somewhere in West Africa, it means something else. It's diverse, right? So I think we need to be flexible. So for now, I don't have an answer per se, because we are yet to have regulations or proposed regulations that would propose how we deal with that. But as it is, as the way the Traditional Knowledge Act is drafted, and even the international conversations have been going, we are trying to assert these rights over language.
Yeah, and also when you're registering, for instance, if she wanted to register, let's say Utamaduni Arts as a trademark, there are those words that she will be required to disclaim exclusive use of. So again, within the realm of what you're talking about.
Yeah, so the ordinary words.
Yes.
Yeah, because again, with trademarks, it's about the ordinary word. So for example, Utamaduni in Kenya, that's Swahili. It's a very ordinary word. And depending on the business that you're using, it might be descriptive. So like if you're in the cultural sector, in the arts sector, it's likely to be descriptive. So you may not want to use it to begin with as a brand. And then in some other spaces, you'll be told, of course, either to disclaim and even translate in some instances, so that now even they are able to confirm whether it's descriptive. It will be the same thing if I went to register a brand in France, for example, and it's descriptive. They will ask me to translate, and then if they realize that I don't know, the construction business and I sell houses, and then my brand says Liz's Maison. Maison is French, in a house for French. And then I tell them, Liz's Nyumba, or vice versa. So if it's here in the Kenyan context, I say Liz's Maison. The minute I do that, Kipi will tell me, give us a translation and say it's house. And they say, this is descriptive. You may want to, change, rethink your strategy, kind of thing. And it will be the same thing there if I decided to register something Nyumba and it's descriptive in the business that I do. They're likely not to give me, even though it's unique. I may get away with it, but the minute another Kenyan does that there, we have to coexist. So those are some of those conversations and thoughts you have to have through your mind. And that is why an IP lawyer always becomes important when it comes to this process. Yeah.
Yes. As we wind up, actually, I'll want you to talk more about that and why there seems to be this, I don't want to call it apathy, but almost as if many folks think that I shouldn't give my money to a lawyer to help me sort out certain things that I need to sort out. And then they regret much later when they lose, particularly on IP. When they lose, they regret and wonder, why didn't I consider consulting an IP lawyer? So we'll talk about that towards the end. There was another question from an anonymous attendee. In what ways can a small business fashion designer protect their design from being copied by big companies?
That's a very broad question, very broad. So I would say that at the end of the day, as this upcoming designer, you interrogate what kind of designs are you putting to the market, what's unique about them, who are you likely to be competing with, what are those challenges that would interfere with you commercializing your IP and making a lot of money from it, or establishing your identity. And then based on that, we are able to advise. Again, it will depend on your marketing strategy as well. How are you planning to market? What are these elements that are protectable? So with all that, we're able to say, okay, then you have option A, B, and C, because this is how you want to go. This is how you want to run your business. So there is no clear-cut answer to that question. It would be subject to the different quote unquote small business and the goals that they have and the designs that they generate.
Okay. Thank you. I see somebody wants us to move quickly to animation and the law. So I don't know that to start this off with somebody asked a question on my phone, but it's a very long question. So it's about whether it is safe to create an animated character based on my photo. So let's say I go to a studio and then they take my photo, and then one day they want to run like an ad on YouTube, but now my what do I call it? My photo becomes an animated version. So do they have a right to do that? As we start off this discussion now on animation and the law.
All right, so let's put it this way first. When we in that context, I earlier mentioned that when it comes to copyright and photography, there's a related right. I use the word related right loosely, but there's that right that accompanies this copyright, which is the image rights. My image, without my face or your face, there would not be a picture, right? So you find that at the end of the day, because these rights go hand in hand, I must seek Helen's consent before I turn her into a derivative work. Sawa, yes, I have the copyright in the photograph, but I don't own your image, and I can't control how you do it unless you give me the permission to do so. So in the event that I decide to create an animation based on someone's image, then I must seek consent. I must have an agreement in writing with them, and I must be clear what I am trying to do. So again, that contract cannot try to claim heaven and earth from you and take away any opportunities from you. Yet all I want to do is just, create, a cartoon for an ad or something like that. So permission has to be sought on if you're using an existing person, regardless of them being a celebrity or a non-celebrity. Yeah, permission has to be sought because everyone has the right to their image to be protected, their reputation, and how it's used. So I'd say that when it comes to using a person's image.
Okay, so would you consider that whatever this person wants to do, is that a derivative work?
Yeah, to an extent, of course, it would be a derivative work because there's a photograph and then now it transitions into a cartoon, an animation. I make from a picture to an animation or a caricature, right? So that's a derivative works. So again, when we talk about copyright, some of the exclusive rights that you get in copyright, remember I talked about copyright and how it protects literary artistic works, the whole shebang. So animation is under that category. So one of those rights is to control, the author has the right to control derivative works. The derivative works can be created by the author himself or a third party. In instances where it's a third party, then the third party must seek a license from me to be able to use that to create that animation. So for example, now the cartoonist here would have to seek a license from the photographer. So Liz took a photograph of you. They come to me and they say, Liz, I want to take your picture and convert it into an animation. And then even for them, they now have to go further and now clear the image rights with you and say, oh, I'm doing an animation and are you okay with me doing that? And this is what I want to do, and have a subsequent agreement. They cannot rely on my agreement with you to do what they want to do, because even me, I don't know what they're trying to do, right? They could be doing other things that affect your personal rights, which I have no idea, like in terms of what you want to do with your image. I think that is the one thing that people usually get wrong and they also don't pay attention to, even when we're using photographs online, right? You just say, oh, yeah, it's royalty free. My friend, read those terms and conditions. Half of those platforms have not cleared image rights. But guess what? We are all busy taking these pictures. We are putting them on our websites. We are putting them on our banners, just because we're like, oh, I don't know this guy. But eventually that guy will crop up. It's someone who's actually existing, unless they are dead. They might come back. They can come after you because image rights. And it's a
Oh, you
common law
mean
right.
like the stock photos that
Yes.
people use?
Yes.
Oh, really? Oh,
Yeah.
okay.
People are not reading the fine print.
So, what about where's the place of caricatures and parodies within the IP space?
So, depending on context, we have what we call exceptions to copyright. So under exceptions simply mean that I do not need to seek the author's permission to use this works. So of course it's education, but it has to also be reasonable. So just because I go to school, if I take a book written by Helen and I photocopy it from page 1 to page 100, that would still be copyright infringement. But if I photocopy like 3 pages, 4 pages for some classwork, that's all right, yeah, because that is reasonable use. It's an exception. So again, even with these exceptions, we have some limitations to them. So apart from education, there's research. I'm using your work to develop further some area of whatever it is. And then there's commentary or review or news reporting. That's an exception. And then we have now what we call parody or pastiche. We're making fun of something to make to pass a message across. Again, sometimes I feel like some of these things can be challenged because we've seen, morph into a few things. But yet, again, we've not had anyone challenge them. So which means like if you did a cartoon and then I use it and I make fun of a certain issue and I publish it, ideally I should be fine. But again, it can be challenged if you can prove also that there's some damages on your end, that you're suffering to an extent because of this use. Because the thing with exceptions is it's not to punish the author or to take away something from the author. It's supposed to temper things down and create some sort of balance. So to an extent, it's okay, but in my view, to an extent, it can be fought. We are yet to have any case law in Kenya, but if you just look at how we've tackled parody and music, we've seen them become totally new assets, right? You see, this song has been turned into some political satire. The next thing, it's on people's ringtones. Is it fair for only this comedian to make money, and yet there's an original author, right? Isn't that derivative works? Those kind of conversations. So I think hopefully eventually, the more we're having such webinars as well, the authors and the creatives are aware of these things, and they can fiercely also protect themselves and fiercely challenge some of these things, where even now the courts can complement the law and say, okay, this is what is fair and this is what isn't fair. But as long as we are afraid, we'll still be, even for me, I'd be making comments and I say, oh yeah, yes, no, because,
yeah. So what's the place of GIFs in all this? You've seen this
so
like they'll take your photo, you'll be captured like somewhere in a rally with a certain expression on your face. Next thing you know, it's all over Twitter. Even when guys are responding to something either funny or mocking someone else, you'll see your image is part of what is in the comments. So,
Yeah, so the use of GIFs becomes very interesting and complicated because we've already touched all these other rights. Yeah, we've touched the image rights situation, there's the copyright. Now with GIFs comes a designer who creates it becomes another derivative works. There might be another conversation around you being in a public space, you were at Safari Rally, we took a picture of you. It's a whole situation. So I think the reason people will not fight, or I would say shouldn't fight, but maybe will not fight, is because of that whole personal use, because again, on social media, there's to an extent you can claim personal use, an exception of copyright. I'm using it for my own pleasure. I just happen to share it, with my friends. So it can be personal use. It will change dynamics when it's now my business using this picture to market my services. Of course, now that would change, and perhaps I need to find out all these people who they are and compensate them. So for personal accounts, we can get away with a lot of stuff because personal use, we are not trying to gain monetarily. But the minute you start using this work and gaining from it as a business, then there becomes a big issue. It becomes a situation. So from GIFs to what are they called?
That is, there's some sort of control that is required here, Liz. So you just turn me into a GIF, even when
that's the
I
other
don't want
thing. Because that's the other thing. When you look at some of these GIFs, these are people from Sijui, Asia, like all over the world. How do I even know this is Helen from Nairobi? Let's just begin. So, but of course, in the context of a corporate, because deep pocket principle applies, whenever we are suing, we're always looking for the one who can pay, right? For those deep pockets, it's prudent for them to do all that work. So I would even tell them, just make your own pictures, pay someone, pay models, take your own pictures and take away this hustle and drama from away from you. But yeah, there's a lot of issues around that. We've seen now the EU trying to assert copyright on memes. And the question would be how, but it's a thing. Because again, at the end of the day, even a meme has a creator, right? It's again, depends on the nature of the meme and the other related rights around it. So you find that it can be complicated and it will be on a case-by-case basis.
Okay. You talked about pay models and find people that, you can use in all this. So who owns the lookbook, for instance? Is it the contractor? Is it the employee? Is it you? Who owns it? Like I'm getting into the realm now of, I think, works for hire. So who owns? Like if I decide today I want to do a shoot somewhere, and I need certain models. If I pay them, do I own that work?
All right, Sawa, let's use that lookbook example. And lookbooks are more common in people in the design space, so fashion designers, interior designers, and people like that. I need models. So first things first, I need to have a release form and tell them, hey Helen, I heard you're a fabulous model. I want to take some pictures of you. They're going to belong in a lookbook. The purpose of this lookbook is to showcase my fashion line, or I'm going to find buyers abroad or whatever. Again, that contract has to be specific, right? Because at the end of the day, you're going to pay me peanuts, so to speak. So pay me according to how you're going to use my image, in all fairness. And I think that's even applied to especially the people in the agency world, because they tend to really misuse models. So let's be very categorical about that. Then we do a contract. And then you've hired a photographer, yeah? So already they're a work for hire, and specifically you want their image. So their contract will be more of a release form, accepting for their image to be used. You've paid them. If it's a shoot for the whole day, you've taken care of their lunch, all that. Then I have a photographer, and I'm specific, because now the photographer is the one who owns the IP, and they need to transfer it to me because I don't know how to take pictures, right? So now I'm giving the photographer a work for hire agreement. I'm basically telling them that they are hired personnel or they're contractors, and that they're working on my behalf, and all the IP that they generate and all the rights that are accruing thereof are mine. They transfer to me. I pay you, you walk away. Again, with copyright works, the only thing that they cannot transfer, that a contract cannot transfer, is the moral rights. So as I use these pictures, I have to say, I have to find a way to always attribute it to the photographer and say photography by so and so. I have to find ways, right? And even give him some portfolio rights. They can just use a picture and say they worked for my campaign, for example. Yeah. So, but a work for hire agreement transfers all those rights, all the other commercial rights in the work, to the hiring party. So the same thing in an employee-employer relationship. Any work created by an employee belongs to the employer unless otherwise negotiated. So again, even for the employers, it's important to know that IP can also be negotiated depending on the person, depending on their impact and their input, and the potential that this work is being created has, right? It's only fair that they are compensated. So if I'm going to create something that will give you, revenue in the millions of shillings or dollars, I mean, come on, it's only fair that if I negotiate and I can already see this and I say, oh, Helen, by the way, from what I've done in the month, at the end of the day, you make X amount of money in profits. I would like 20% for the next 10 years or whatever. I mean, yeah, but that's negotiable. We don't see a lot of negotiations happening in terms of IP discussions with employees and employers, but it's something doable.
Okay. So let me give an example here. I commission you to come and take videos at my relative's funeral service, or even the whole funeral thing, when you go to inter the remains of the person. And next thing I see is you are advertising with my video on your Facebook. I know dead people have no rights, but I'm the one who commissioned you. Like sometimes it's so offensive. They actually go and you can see the coffin, in some cases they haven't covered that place, so you can actually see the deceased. Oh. Yeah, so which goes back to what I was saying earlier, that we have a lot of creatives that don't seem to understand some of the liabilities that come with the work that they do and the attendant rights of those persons. Forget about now your rights as a creative, but what about my rights?
Yeah. When you mentioned that, but there is a certain law. I can't remember which one, but I remember a few years I cut on it because I had a client who almost published a picture of a deceased online. And there's a law that prohibits that expressly. Like, you're not supposed to share pictures of dead people, period. Unless people are acting and then someone is playing dead. And you have a license from KFCB, because they'll have vetted that scene. So ideally, that's not supposed to happen. And if you do, you're liable for an offense. And I know the fines are not small for that. So whoever is doing that, or whoever didn't know that, please know that today. The question around them using it to advertise, of course, you can stop them if they're advertising their business. And it even gets worse if it ends up being an advert, like a proper advert on TV. There'd be so many opportunities to tackle that issue. And to an extent, we can even find a criminal angle depending on the situation. So but as you aptly said, I think as creatives need to understand that it's not just about their rights, it's a balance of rights. And that's why we have the Constitution. The Constitution is the primary document. If anyone tries to read it, and they should try to read it, they will see that there's that balance. There's a give and take when it comes to these laws. No one can suffer or benefit to the detriment of another. We are all humans. We are all citizens of the same country, and we need to live in harmony. I think that's something that they always need to know. And I think for those who are here listening on Facebook, in this Zoom call, we say that ignorance of the law is not defense. We have Kenya law, EKLR. I forget the full URL, but just go to Kenya law. You will find all the laws of Kenya there. So that premise is based on the fact that you have access to these laws. So if you can't read them, then find someone who will help you read them so that you know what this law is. Because at the end of the day, you will not be in court and say, Your Honor, I did not know. So the other day I was speaking at an event. Kipra was having the annual conference, and I asked the people who were in attendance, how many of you have heard of Kenya law? And a handful of them put their hands up. A room of like 100 plus people. I think I saw like 5 hands up. I told them, boss, it's available on your phone with your 2 bundles. You can go online and read the Constitution, the Traffic Act, and whatever act that you feel like you should know because it speaks to your business and protects yourself. So it's the same thing for creatives. There are all these other rights. So again, speaks to the issue why you need a lawyer, because we're able to see all those issues, all those liabilities. Some of them you can't even anticipate. We're able to put it to your attention and say, oh, you want to do this, then you need the following permissions, or you can't do this because there's a certain law somewhere that prohibits you from doing that.
Mm-hmm. Okay, so there are a couple of questions here. I'm not sure whether we've satisfied you, anonymous attendee. You have a question about where can I register animation and what type of rights can I have over it? Polycarp, I think I'll ask this question of yours towards the end about the inter-conference that Liz attended. Francisca, there's nothing new under the sun. In the world of visual images, to what extent do I have to modify an image for me to no longer be accused of infringing on another's rights? Okay, where did it go? And then she says, for example, I never met the late Nelson Mandela. I'll rely on photographs to create his animation. To what degree do I change the images I use as reference to avoid copyright infringement? And as you are responding to this, Liz, is there anything that we can call, like, is there something called a principle of transformative animation?
So that takes me back to, there's a principle of transformative use that's a little different from transformative animation. So here in this regard, first of all, if we're speaking about Nelson Mandela, we have that issue of image rights. And there's a way that the Mandela family has protected the image of Nelson Mandela. They have become properties of the Nelson Mandela Foundation and family. So when we're dealing with personalities, there's a whole bunch of issues that need to be tackled and rights have to be cleared. And especially if you're going to commercialize, especially, there's the exception of personal use. If I'm just doing this picture for my own personal use, that's fine. But the minute I start commercializing, that's another conversation. At the end of the day, when we're talking about derivative works, if you did not take the original work, then you must clear the rights. You must get permission from that person. I take a picture of Helen, I put it on my computer, and then I start giving her horns and sijui what, blah, blah, blah. You know, whoever the photographer was, I need to tell them, because there's a way they will also be able to prove and show that this is the original work is here. So if it's not yours, clear it. If not, create it from scratch. Regardless, yes, a giraffe is the giraffe. But just because I took a picture of that giraffe doesn't mean you can take that picture and do whatever you want with it. Go take your own picture of the giraffe.
Yes.
And decide how you want that giraffe to stand or whatever it looks like in that picture. If it's not yours, clear the rights, period. That's how I would answer them.
Thank you. A couple of more questions still on that so that we can move swiftly to music because we don't have much time. Susan Guya. Hey, hi Guya. Speaking of image rights, what can you say about release forms broadening the range of use for images? There's the data protection aspect, but some have been revised to include permission to collect biometric data and use it for purposes other than stock photography. Would this fall under infringement? And then can you also talk about how deepfakes may affect intellectual property rights?
Okay, so let's start first with the image rights question. So if you find yourself in a situation where the contract was so broad that it tried to enter into the realm of personal data, then that is something that you can fight, and you can fight it under the data protection principles and act. And I think right now, because data is so big and the protection is also so robust, I think right now no one wants to mess. People are being very should I say particular in terms of the GDPR and how these rules affect their business, and they're being very deliberate. in the Kenyan context, now we have the Data Protection Act, we have the Office of the Data Controller, the name has disappeared, but we have an office established under the Data Protection Act as well. We have data controllers, yes, ODPC. We have the data controllers and controllers, and the one has now disappeared. The name has disappeared, but there are types of people who use the data, and they have certain obligations under the Act. So are you a controller or a processor? That's the word I was looking for. You have certain obligations, certain licenses. So if you take up my data without my permission, of course I will come after you under the DPA, and you deal with the law. So, but anyone who wants to use such data, you have to be duly licensed under the DPA, and your contracts have to be very precise. When you're using data, you must say, I'm using this data for purpose X, and that's it. You're not allowed to meander and try getting all these other potential rights or permissions without my permission. So for every permission that you need, I must expressly say yes. Yeah, and that's the basic principle under that. The question on deep fakes and how they affect intellectual property rights. Yes, the deep fakes really affect IP rights, and especially when it comes to the context of fashion. And I think right now more of these international brands are seeing that, because they are losing the millions of dollars in the millions of dollars when it comes to them not protecting their IP outside other countries. Because if you look at Kenya, the number of fakes we have in the fashion space already are enough. Like, it's so much. You go to Dubois Street, you go to all those streets downtown, you always find knockoffs. There are similar streets in the respective towns. It's quite a lot. And we've seen that in terms of even how Kenyans appreciate intellectual property rights has really changed. I have had clients who come to me and they tell me, Liz, why do I need a trademark if Givenchy is being knocked off and they're still making money? I'm like, why? It's useless. And I'm like, yo, you're not Givenchy, but hey, you're not Chanel, but if that's what you want to do, it's okay, do it at your own peril, you know? So we've seen that a lot. And I think, like I said, now a lot of these international brands in the different areas are becoming more proactive in protecting their intellectual property in the different countries, and which is subsequently also showing Kenyans that it's important to protect your IP. I can say that with a fact, because during COVID, because so many businesses went online, even now the international brands started, making sure that they were protecting their brands online. A lot of even Kenyan content creators and businesses had their pictures taken down for either copyright or trademark infringement, which subsequently saw a couple of brands registering here, and also saw Kenyans asking themselves, what have I done wrong? What do I need to do to make sure that my business is protected and my brands are protected and my IP is protected? So we have now seen that ecosystem is really interrelated, and there's a lot of development happening in that space now.
Okay, thank you. There's another question on registration of IP on animation, and whether you could provide estimates on registering creative works. The anonymous attendee says that a lot of artists don't bother to do it because they worry that it might be very costly. This goes back to what I said earlier, that people don't really think they need lawyers, particularly in the creative space. And then,
I think in terms of, okay, yes, if you're protecting an animation, it would be copyright. But ask yourself, as a business person, what are my goals? Because I think we miss the point when it comes to IP. We only imagine that once I have registered, I'm good. With the registrations come issues. Did you commission someone? Do you have the right contracts? All those issues need to be tackled before you even go to the registration bit. And then after the registration, what is your plan? What kind of contracts do you get into and all that stuff? So that means you have to invest in a lawyer who help us, specifically an IP lawyer. And if you get an IP lawyer who understands your industry, the better, because they're able to walk 10 steps ahead, 10 steps back, 10 steps, 360 around you. And they're able to say, you can make money here, you cannot make money here, you can explore here. Like, they're able to do that, right? So we need to start thinking about legal fees and lawyers as an investment and not some sort of expenditure or loss that we are incurring. Because guess what? The minute these people, another party comes after you and you are not protected yourself, that is money you're already losing. And you're going to lose that money tenfold, as opposed to the amount of money you would have paid for protective lawyering. Defensive lawyering is going to cost more. Because remember, even now for this lawyer, they will put on their fighting armor, they are reading all these books, they are reading case law, they are preparing court documents. Of course, it won't come in cheap. There will be moments, Helen can attest to this. There will be those moments you can't attend family events because you're busy in the office, drafting pleadings, you're crying, you're, you have
certificate of urgency.
Imagine all those things. And then you expect me to charge you 5,000 shillings. Of course not. You'd have probably paid 5,000 to come into my office and I tell you, Helen, this is your plan, this is what you need to do. Go and sit and think about it and come back, and then we strategize how you're going to do this. Now you come back with all this legal drama. That 5,000 has turned into I don't know, 5 million, depending on the nature of your dispute and who you're fighting with. Yeah. So I think people need to start embracing protective lawyering more. And I want to make this comment with due respect to our intellectual property offices. Please let lawyers do their work, because we have seen instances where clients will walk into an IP office and they are told, yeah, this one is a trademark, you need class X. By the time the person realizes they've done the wrong thing, it's too late. There's either some opposition or something, like they can't assert those rights, and maybe they have to go back to scratch, right? You get a certificate without the proper understanding and what's it called, interrogation, and then you find out that at the end of the day this person actually was not the legitimate owner of this work, right? So I think it's really important that the legal system is embraced when it comes to IP and IP protection, and we stop telling people to self-lawyer. There are some aspects, yes, you can self-lawyer, but you can't self-lawyer if you've not even seen a lawyer from the beginning to guide you. You'd rather come to an office, a lawyer's office, and say, okay, me, I can only afford consultation, but I would rather protect myself, help me protect myself. And then I'm able to say, okay, this is what I will charge you. This, I prepare you to go defend yourself, sort of situation. Then you don't go all blindfolded and start doing things just because you think lawyers are expensive and whatnot. Everyone is gifted in their own thing, and lawyers, we went to school for so many years, we are still learning every year. Everything, if the law is always evolving and changing, so you cannot try and purport that now you understand the Data Protection Act. Even for us as lawyers, every time someone asks me a data protection conversation or question, I will be like, give me an hour, I just refer and I go read the DPA, I read the GDPR, I read all these things, and I say, okay, now I think in your situation, this is how it will be. Yeah. So I think professionalism, especially legal professionalism, needs to be embraced, and we need to appreciate its value, period. That is why, again, when we're talking about IP, people need to start looking at the international like brands and IP and just see how fierce they are. None of them show up self-lawyering. If you just look at, for example, Beyonce and her brands, the Blue Ivies and whatnot, she has been fierce about it, and she doesn't do it herself. She has a legal team. She's even sued. I think there was even an IP situation with a church that tried to use Blue Ivy, and it's a strategy. They know why they want to protect that brand, and even a church is a business, right? So all those things, just have lawyers, period. That is why these other brands are successful, these other companies are successful, because they deliberately invest in lawyers.
Thank you, Liz. Okay, now we move swiftly to the most favorite part of this IP discussion, writing music. We want to talk about music, IP in music. So I want to use an example. There was this whole hula baloo about, the Kenyan example would be Sauti Sol and this part of their song being used by one of the political parties or one of the coalitions. That's the Kenyan example. And then there's another example, and this speaks to how you negotiate a contract. So Snoop Dogg and Dre, what kind of contract did they have that they were so happy to get out of eventually?
Mm-hmm.
And then Bad Boy Records and the artists that were under that stable. Just for us now to begin the conversation on music.
All right.
And IP.
So
yeah,
I'll start it from the basics. When we're talking about music and copyright, because copyright is the main protection for music, we need to have that. You need, as an artist, you need to understand what is copyright and what is related rights, because there's copyright and related rights. And then understanding who owns what. That is where the conversation always has to start. So in music, we have the copyright, who owns the copyright in the song. We have the author, composer, and arranger. Those are three roles. The composer is the one who creates the melody. In street lingua, they call them beat makers, but they've actually composed the melody. And then we have the authors who write the lyrics. And then you have the arranger who basically now arranges the music and able to say, play here, do this, arranging the music. And then now the fourth person by way of a contract is the publisher, who helps commercialize this music, and they get their cut as a publisher. So they have a publishing agreement and they belong under that body of copyright. And then subsequently, we have now the collective management organizations. And like in the Kenyan practice, these people I have mentioned, these parties I have mentioned would belong to Music Copyright Society of Kenya, because it represents the composers, authors, arrangers, and publishers. Yeah. And then we have the related rights. We have the performer rights. The performers, these are the one track producer. I say the one track producer deliberately, and because we have seen that this fancy machinery has come to replace instrumentalists. Ukiingia kwa studio, you always see this nice thing that looks like a keyboard and all these two things, and the guy will just press one button and he can play the drums with the button. He plays presses another button, he can play the flute and all that stuff. So by virtue of that gadget, he's a performer, because he just performs the different instruments from that whatever. So that track producer is a performer. Then we have the singers, the rappers, the actors. Those ones are under that related right. And they have a CMO for that, the Performers Rights Society of Kenya in Kenya. Some countries, they have one CMO, but in Kenya, we have PRISC. And then we have the producer. The producer is the person who finances the recording of the music. So the person who pays for the sound recording owns the producer rights. He's the producer in the legal sense. So he owns the master rights. So with that understanding, when you have a record label engagement, it's always asking yourself about the kind of control that you give a label in terms of the work that you create and in terms of how you work together. We've seen over time that the relationship between artists and labels is evolving, right? But then in the traditional sense, or what used to happen before, because the label would put in all the money, the label will invest in the sound recordings, in the music, they make sure the artist is properly dressed, the artist gets to the studio, like they put in all that money. So because of that, you would find that at the end of the day, they would get a chunk of the royalties to recoup their costs, and something small is given to the artist. In some instances, there is should I say like a signing bonus that is given, and you're told, here is your money, but this money is recoupable from the work that you do. So again, when that happens, read the fine print, make sure it makes sense and all that stuff. I think the challenge for artists has always been that we are not reading the fine print. You get a contract, you get so excited, you've been given cash at hand, you see, ooh, a briefcase of 1 million, ooh, I'm rich, and you're quick to sign, you're like, oh, where do I sign? And then eventually you're like, oh my goodness, I sold all my rights. Nobody held a gun to your head. You are either just so excited about fame and being the next sensation that you didn't think through your craft and your rights and how you'd want to work with these people or this label or whoever it is that's in the ecosystem. So I think reading fine print is really, really important, more than anything. At least invest in yourself to know the basics And then you're able now to navigate your craft better. And then remember that with contracts, the fact that sometimes it might seem obvious, take a step back and seek legal advice, and seek also advice from professionals and your peers as well. Learn from their lessons so that you don't make the same mistakes. And I think that advice would cut across all creatives generally. Don't make the same mistake a fellow creative made. Go and learn from them. Yeah. Ask, what have they done, blah, 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 so that then you don't do the same thing. Yeah. So understanding the copyright and related rights situation really helps an artist to understand the broader spectrum of their business. It also helps them understand what is a CMO, what do they do for me? Do I need to be in a CMO and why? And understanding the why, then does this contract make sense? Do I want to sign with them, or what other opportunities do I have? All those things are all based on first understanding the copyright and related rights, and also figuring out how you work together in the beginning, especially now, like for artists, because the other thing we notice is that guys check into studio, they create this fabulous work, no split sheet, so we don't know who did what or who can claim what until they see money. Then they come and they say, wait, Helen, I'm the one who wrote that song for you. Pay me 5 million Kenya shillings or take it down. What is split sheet? The investors have already come into play. Now the situation becomes all murky. So I think we need to figure it out from the beginning and be honest in those transactions at the beginning when we're in studio.
Okay. So in the case of can I decide that I'll just be solely an artist under this label? Because I want us to look at what does it mean when you decide to ignore the fine print and there's an exclusivity clause in that contract that one day you want to get out of and you can't. It's almost like trying to extricate yourself from an auger or a,
So the thing we need to understand is that, especially for music, exclusive contracts are not all bad. It's about that balance. If I'm starting out as an artist, I don't have money. So whoever is going to invest in me, it's only fair that they ask for exclusivity because they're building me from scratch, right? The question is, to what extent do I understand what's going on? And am I ready as an artist? Am I ready for what I'm about to get into? Do I know what it means? Because when you get into a contract, you also have obligations. Just like the other party has their obligations towards you, you have obligations towards them. And at the end of the day, you have to be also very honest with yourself. So if I'm starting out as an artist, I know that they're going to invest in me. Do I write my own music? Yes, if I do, then I want to tell them that, at the end of the day, I want to keep my copyrights, but the sound recording rights are yours. After X amount of years, can I re-record my music if I wanted to? There'll be that conversation around, okay, then if you do, and we had a cordial relationship, we want to work with you with the second album for, the remakes or whatever it is. If I live in a terrible state, then and I still secure these rights, then maybe I have to work with someone else, but there might be some few issues over there. So at the end of the day, I think exclusivity really ties an artist more when it comes to matters distribution. But again, also distribution will depend with the kind of recording agreement I have. So if I'm in a 360 deal agreement, for example, which is most of these artists internationally were in, like the TLCs and the whatnots, they were mostly in those 360 deals. That 360 deal means that the label is managing you, it's producing you, so it's
promoting
publishing, promoting, like it's doing everything for you. Like it's the everything, it's the engine behind your brand. Yeah. So that's the kind of contracts that they were getting into, which means even the distribution, they would handle that. And then in the contract, they would say, okay, when it comes to this revenue, this is how we share it. So there'll be a split, the distribution revenue, advertising revenue, merchandising revenue. If you appear on screen or you end up being a guest, somebody in a movie, like all those revenue streams, you have a discussion on how you share in the revenues, because again, also the artist will also still have an input in some situations, right? So there will be some areas where the artist gets a bigger chunk, and it also make them feel nice. And then there'll be those areas that the label is like, yeah, here we spent a lot of money, so for distribution we will take 60% and pay you 40, or take 70, pay you 30, or whatever it is. And then also have an auditing clause in your contract, such that you can always inspect the financials every year and confirm you've been paid what is due to you and all that stuff. Yeah, but for distribution, of course, if you're especially an independent artist, especially, I think independent artists are the ones who need to even pay more attention. They're the ones who get easily trapped in these exclusive agreements. Because yes, I want this autonomy, and then I end up in some contracts where I'm giving out, I'm exclusive to someone, which means I can't contract with other parties. So those are some of the things I need to think through. So for example, right now, being in an exclusive engagement helps you control your music in different platforms, because all these platforms have different audiences. So I'll just use this as for purposes of education and just for people to understand the different whatever. So I can decide to have my music on Boomplay, I can have it on Dundo, I can have it on Apple Music, iTunes, I can have it on Spotify, I can have it on, I don't know, SoundCloud, I can have it on YouTube, all these platforms, yeah? And I'm able to make money from all of them, because all these platforms have different audiences. But the minute I get into an exclusive agreement, now it's this guy I'm in an exclusive agreement with who calls the tune. And some of them might even decide and say, hey, by the way, I don't think you need your music on this platform. And your friends are telling you, hey, this platform is paying us well. We have our music on TikTok. we are making money. How much are you making? And you've never seen a dime, because someone has decided that they don't think your music should be there. And you know it should be there. And it's actually your right that you can do that. But because you assigned that right exclusively to one person, you tie yourself down. So you miss on a lot of opportunities. And then, there'll be some cases also that exclusivity will come and bite you. But distribution, I think, is one of those areas that it really bites artists.
Okay. So would you say, streaming is killing music?
Not at all. Actually, if anything, it's really giving them opportunities to earn. Like I said, all these platforms have different audiences, and they speak to a certain demographic. So it's about just identifying the different platforms that would be lucrative to you, and put your music out there. All of them, you have different contracts with them, and they'll pay you. And you have those auditing clauses and whatnot. So you don't have your eggs in one basket. You have split them everywhere, and you're making your killing, you're cashing it in.
Okay. I was watching something earlier today on Facebook, and I saw a very famous artist, now deceased. Actually, most of his songs were remakes of originals. And in my view, his rendition was better than the original. And here I'm going straight into the issue of consent. How that right is exercised within music and IP. So if somebody recorded a song in 1920, were there IP rights in 1920?
Yeah. So, of course, like I said, the basic principle or premise of IP, if it's not yours, clear the rights. So ask yourself, what is this work that I want to use? Has it already reverted in the public domain? If it's reverted in the public domain, you can use it. If it hasn't, then you have to seek permission and get the necessary licenses. So for example, if you're going to use American music, you have to go rightfully to the people themselves, the rights holders. It might be the publisher, they've assigned to a publisher, or it might be the record label. Find the right people, make sure you clear it the correct way. Some music, don't automatically assume it's in the public domain, because like for the US, for example, they had a shift of laws at some point, so it affected the periods of copyright on some works. That's information that you need to find out before, instead of just assuming. So that whole due diligence really needs to happen. And then as that is happening, the owner is able to say, okay, how do you want to use my music? In some countries, like us, we are heavy on moral rights. So which means then I have to give the go ahead on how the music sounds or feels or how you use it. The US don't have moral rights on the song, but of course on the exclusive rights that are granted in copyright, you have to respect that. So you have to get the necessary permissions, and then you have the right license. So for example, I'm going to re-perform a song, I will get a mechanical rights agreement, either from the publisher or the record label, or if the author represents themselves, from the owner of the song. If I'm going to use that song, the sound recording itself originally, then I have to find the producer or the label and clear those rights so that I'm able to use that recording again and reuse it or whatever the case may be. Yeah, so there's a lot of due diligence that happens there, and then the rights are cleared. The advantage of that is that because now you're doing it legitimately. Remember, with all this work, there's some investment. You have those lawyers, you are paying studio time, you're shooting videos, there's all that investment. For as long as you have that permission, then you legitimately gain from it as well, because you have the right permissions, right? And that means that your money, your investment will not go down the drain. In the event that you do all these things and you don't have the right permission, guess what? You're using someone else's work. It's an illegality. You will not benefit from an illegality. Yeah. So which means all that money that you spent means nothing. It will just, and you're done. But you have the necessary, exactly. But when you have the necessary permissions, you can now have your music on all these platforms, on YouTube, and on the back end, you're splitting the rights, or rather the monies, with the rightful owners, and you're cashing in. You are able to negotiate for yourself and say, you know what, I'm an African artist. If I did your song with I don't know, a Kalenjin, something, I'll bring this kind of audience. I see this amount of views or blah, blah, blah. How about I pay you 20%, I keep 80%. Sign a contract. They share that contract with YouTube on the back end. Everyone makes money. We are good. Yeah. If we do not have the permission, it's an illegality. Any lawyer will tell you for a fact there is no way the law will, help you benefit from something that is already illegal.
So these choirs that decide, oh, I'll remake a Hillsong beat and have a Kiswahili version of it, they have to get all this clearance.
Yes, ideally they should. The songs that exist in the platforms like the YouTubes, because I know I get questions that, oh, but I put this song and no one ever asked me. It's because on the back end of some of these platforms, the rights holders have already told the platforms, you know what, because we are in, perhaps, like, I imagine that for gospel guys are like, you know what, because we sing about God, let's not fight about it. But on the end, because of, there's rights, watch our upload, but all that money comes into us because these guys have no license. If you have any license, we'll declare and we'll let you know how we're going to split. If no one has a license, you don't know, everything comes into. So in the back end, the guys are making their money. You over here, you're like, oh, it's a church song, it's free. Oh, we have 1 million views. Guess what? You didn't clear the rights. So the rightful person is making their money. You're just like, yeah, I'm famous, period.
So like when I go to, let's say, Safari Park on a lazy evening, and there's a band there doing cover versions of the Mushroom songs. It's diverse. They'll do Adele, they'll do, the one I've never had them do is Beyonce, but they'll do Adele, they'll try Emily Sandé, they'll try, So they also need clearance.
So for this particular guy,
that's fair use. So what is that?
No. So for establishments that play live music, they get a license from the CMOs, because that's what we call public performance, or performance in public places, depending on what term they use. So these people have licenses for that. Ideally, they're supposed to declare the songs that they have whenever they take out a license. Or if they have that blanket license, every month they should submit a list of the songs that they perform at their establishment. In some instances, they have like a specific license. If like it's a once-off event, you'll take out a license and negotiate with the respective CMO, and then give them your your list of songs. So they get a license from the CMO and that's it. But it will change automatically. The minute that performance is put on YouTube, that conversation will change. And it will be either on the back end, the artist or the rights holder has said, let the money stream into our account, or they say, do not upload, take it down, take it down, take it down. So that's when you see that flag, that copyright notice being flagged on you, and they are like, this is not yours, you do not have the right, la la la, down. So because again, the right to control is an exclusive right of an author in copyright works. I have the right to control. I can decide whether I want you to share my work or not.
Yeah, I found that what you've just talked about. So let's say I take a video of you right now as we are doing this presentation, and then I want to sample a certain song to accompany this video. I've seen Facebook is very quick.
Yeah.
They will not actually, that video won't be uploaded.
Yes, because they'll be in trouble. The deep pocket principle, they'll be the ones in trouble. So they will nip it in the bud very fast because they don't want to enable infringement. If I don't have the permission on your behalf, I cannot let you use it.
So they are what I like to call the brand soldiers are very active somewhere.
Very quick, because that's money they're losing in real time.
On their desks.
Yeah, that's money they're losing in real time.
Okay, yeah, so that actually answers the question that someone had asked. Do bands then have a right to sing songs by artists to entertain the masses? So that has been answered. When buying beats from producers, e.g. online or YouTube, is it the responsibility of the artist to ensure sample clearance? And then this one that you were very passionate about, I think you've answered this question. That as a music artist, when starting to design your brand, should you work on it first, then present it to your IP lawyer? Or should the IP lawyer be with you from the beginning as you build the image of your brand? I think you already answered this question. You said we must work with IP lawyers from the very outset. Yeah, so this last two questions, this one you've already answered just now about whether bands have a right to sing songs by artists.
So for these ones who are buying beats online, read the fine print. Terms and conditions apply. Go and read those terms and conditions. Do they make sense? Do they protect you as a business? Might there be any further obligations on your end? Those are the questions you ask yourself. So, just don't be blinded by the word, oh yeah, we have free music online, or we buy music from producers. You see, at the end of the day, if producer X has not cleared the rights and I sell it to you, if I have any liability, I also transfer it to you. Yeah. So you also have to do your own due diligence, which includes reading those terms and conditions. Are you able to confirm that this is the legitimate seller, or you're going to be in trouble? Do they have the legitimate licenses or rights? All those things, you have to do them from the beginning. Otherwise, whatever liability they have, they will transfer automatically to you.
There's a comment here from Thomas or Pande. What I know is after 25 years, music becomes a public domain, as in you can sample music that is over 25 years, and that's why I've picked it. I wanted you to speak to that and get away with it. But it is always safe to get permission from the artist or publisher. And so I want us to talk about what DJs do generally.
Before we start talking about
I find on YouTube, and then they say, leave Lenjo mix R&B from the, I don't know, 2000s and 90s. Yes.
So first, let's start with that comment of 25 years. It's a lie. So like I said earlier, when I talked about copyright, I talked about duration of copyright, and specifically for music, for the lifetime of the author plus 50 years in the Kenyan context. In some countries, it's plus 70 years from the after death. So hakuna 25 years hapo. Yeah. For the sound recording itself, it's 50 years after it's been produced. But again, sound recording, what will you do with it, honestly? Like, sawa, to get in the public domain, but question mark. Yeah. So please, no 25 years. plus 50 years and above, depending on the jurisdiction after death. So lifetime of the author plus 50 to 70 years after death. That is the validity of copyright in musical works. Now, DJs have a complicated situation. For the, from my understanding is that how DJs came to be at first is that record labels, when they, especially the record labels in back in the day with the 360 agreements, they needed to figure out how they would boost the listenership of their music. So what they would do is that they would work together with DJs, either pay them or hire DJs to specifically boost their music in clubs. And that's how they would they would make or earn their ends meet as DJs. Over time, we have seen now DJs are doing mixes online and whatnot. And in the strict principle, like I said earlier, if it's not yours, clear the rights, right? So over time, we have seen, when we're talking about distribution and online exploitation, we have seen that the rights holders, the record labels have been flexible in terms of the kinds of rights that they can give to DJs. And that way the playlist will stand online, like they'll still exist. If a DJ is able to negotiate properly with the rights holders, then they may be able to share in the revenue. If not, if you're already using someone else's work, you don't have the express permission, you're sort of benefiting from money legality, you will not make money. So that relationship needs to be established and a conversation needs to happen if you want to make money from your DJ mixes. Otherwise, the current DJ mixes as they are, like I said earlier, it's the back end, the rights holders have decided, you know what, it's okay, we'll keep making our money and your list or your mix continues to exist. We've also now seen some of these labels also now are able to assign some of these rights to some of these platforms, where now they can legitimately ask for DJs to create mixes. And then you're able to say, okay, DJ Helen, create a mix for us. You can earn 20%, but at least because we have the right from the various rights holders, the labels and the publishers and whatnot, we're able to give you 20% and we are paying the rights holders their money, and we are earning our small admin or profits or whatever, right? They're able to do that. So at the end of the day, if a DJ really wants to make money, they have to be very strategic with it. In the traditional model where they go to a club and perform or play all these mixes, they take out a license with the CMOs. They, like MCSK, Camp Priest, have a roving DJ's license. So if I'm a roving DJ and I'm not attached to a club, I have a license. The last time I checked, I think they were paying like 20K a year or something like that. If I don't have a license, then the club where I play will have a license and they protect me. So all I do is I come and I play, I'm paid like a salo or a performance fee. I come, I play the music, people dance until 4 a.m., I go home. Yeah. But in terms of rights, no, unless now you go the DJ Khaled route and you're now creating beats, and then now you want to be known as DJ so and so, but you're a beat maker, aka a composer, then there you have rights. Yeah.
Okay. Thomas, you've had, it's not 25 years. There's a question here from an anonymous attendee. Are there platforms or institutions that monitor a music artist's work to prevent copyright infringement, or how should you monitor, e.g. radio plays?
That question is interesting because over time we have seen now, I don't know if I should just say some people are lazy when it comes to content acquisition. So they'll just be like, turn the YouTube to download. Yeah. So when it comes, first of all, copyright, as a copyright holder, you have the right to make your work available and you choose to whom to make it available. So I think even for broadcasters, we need to stop assuming that just because it's on YouTube, I have decided I wanted to make it available to everyone. YouTube has a certain demographic, I may have a certain demographic, so I think it's really important. So in a situation where your music is being played without you making it available yourself deliberately or through your agents, then you would it's upon you to police your work and make sure then that you're protecting yourself. If you want it taken down, you have it taken down. You hire a lawyer and they help you figure out a proper strategy for you. If it's online distribution, yes, there are platforms that help you counter copyright infringement, but some of these platforms are in strategic relationships. They're in strategic relationships with digital platforms that you're putting your music on, and they even may expressly ask your permission to help you police your work online, right? But it's something that you have to invoke/push for yourself. But in the traditional sense, you have to police your work, because intellectual property rights are personal rights. Just like how I would, you close your house and go to Shags for holidays, you make sure you left a watchman, you have CCTV, you have all those things. It's the same thing with your work. You have to figure out how you're policing your work to make sure you protect yourself. And if anyone tries to use your work without your permission, yeah, you deal with them accordingly. The same way, someone will come into your house without your permission and you'll have them arrested for trespassing. Yeah, that's what I would say.
Yeah. Thank you, Liz. We've come almost to the end, and this is the part where I thought we should focus on, so what are the new things you learned at Inter? I know once you go to these conferences, you come back home and you're like, why can't we do things like this? And, because we are still relatively like infants in as far as protecting our IP rights are concerned. So if you could kindly just share with us some of the things that you learned there in that space. I know there's a lot of stuff happening, particularly in the NFT space on IP and what have you. Yeah.
And that's actually where I was going, because for those of us who play what's that game on the phone where we dress models, fashion something. I used to play that game and then I stopped playing it, because guys legit buy clothes on online clothes to dress models, and you'll never wear these clothes, but like it's a legit business. And just realizing the opportunities that it has for the different people in the creative space, from the fashion designers to the animators, to all these developers. Like there's a lot of opportunity that we're not aware of, right? We are seeing a lot of assets being created in the metaverse, these digital clothing, digital assets. Designers are creating clothes specifically for, I don't know, some cartoons on a video game, and people are playing this game and they're buying these clothes. I need to buy shoes, Chanel shoes for this doll so that I can get points. Like it's legit a business, and we don't have, I don't think we have any African designers, and I stand corrected, but most of them are the Chanels and the Balenciagas and all those. The European designers are doing that. So there's a lot of opportunity. We can create our own games. And of course, the legalities are developing. Yeah. That is something that I was happy to hear, because I've had one or two NFT situations and I'd just be like, what? So I'd have to go online and read. So meeting lawyers who are also now in the thick of things of NFT and the metaverse was really eye-opening. And I felt like I was happy to know I wasn't alone, and that I was actually doing the right thing, because I knew we don't have framework, it's developing. We're doing a lot of trying and testing, which also tells us that even as African innovators, we need to be fierce about trying things out. And for those who are funding this space also should do so without fear, and just don't fear to be risk averse, and just invest and see what comes out of it, and be clear. This may work or may not work, instead of, again, over promising. That's the other thing we tend to do wrong, is we over promise. I would rather just be honest and say, you know what, this is groundbreaking stuff. I don't know if it will work, but if it works, we stand to gain, all of us. So how can we work together? How can you bring in some money? How can you do this? So for me, that was really, really awesome to be part of. So the NFT conversation right now is really huge, the metaverse, and just the online gaming community is really huge. Another thing that I learned, and now we are seeing it in practice, is that now a lot of these international brands are keen on Africa. So it means that as African creatives, we need to have our IP in check. We need to have our structures in check, so that we can attract these collaborations, right? When these guys come to Kenya, they will be like, okay, I'm in animation. Who can I work with? Who looks like what they know what they're doing? Then you need to submit all your, as you're pitching or whatever, you need to show that you actually know what you're doing. Your company is properly constituted. You have been registering your IP. You've been defending your IP, all those things. So that's what will make you attractive to work with these international brands. So I would say, guys, to take the IP game, with a lot of seriousness and fiercely protect themselves and spend money to make money. That's what I'm basically saying. Have your legal in check, have your marketing in check, have a proper team in check. Don't try to be what I call Pekiako Productions. You want to do your marketing, your legal, your design work. Boss, pick a struggle, yeah. It was really fascinating to see that. And now, like I said, we are seeing now Chanel doing its first fashion show, I think in Abidjan, which means now these guys are walking their talk. They are ready now to come into Africa. So, let's be part of it. We've already been seeing other corporates already, having their roots in Kenya. We are seeing Netflix investing in Kenya. We are seeing all these other brands. So if you don't know, if you're not investing in yourself, knowing about IP, having your team, you miss out on this opportunity for sure. Yeah.
Thank you so much, Liz. There's a burning question here. Before I wrap up and do my thank yous and vote of thanks, in the Sauti Sol scenario and the Azimio team, why did they go ahead to claim copyright infringement, whereas MCSK had issued a license for the same?
I can't comment on that because they had a specific arrangement. But if you go on my Facebook public page, Liz Mkamboi Lenjo, I did a video, just a commentary, just outlining the role of CMOs basically, and the fact that contracts are there to be negotiated, and the fact that business models change over time. So with that kind of information, you're able to make sound decisions when it comes to contracting with different parties. So Sauti Sol and Azimio had a step, and MCSK, that was a situation that they have dealt with out of court, and it wouldn't be prudent to even start bringing up skeletons. They've dealt with it. But the basics or the basic issues, follow me on my public page on Facebook. And I did a couple of videos, 2 videos, and just understand some of these issues that you need to be aware of in the music industry, especially in relation to CMOs and use of music. Today, we've just covered like a small bit, but if you're an artist who's here, if you're a creative person, like I said, I hope your take home is that you have a lawyer, have a team, and don't do things blindly. Invest. Legal fees is an investment and not an expenditure per se. It's an investment. We need to start seeing that with more clarity, and then we have less drama in our creative businesses.
Thank you. And that wraps up our webinar today. This has been very informative. As usual, it is always nice hosting you, Liz. The last time I think almost got everybody in Nairobi listening in on the entertainment and copyright law webinar, the first of its kind, I believe. So on behalf of USIU, I want to thank you so very much. And to our participants, asanteni sana for joining us. Keep the conversation going on Facebook, on Twitter, on LinkedIn. And as she has said, please follow her. She has quite a lot of informative videos, and she also has a blog. You can be able to gather more information on IP. I hope we met your expectations. This topic was quite broad, but I do believe that we met some of your expectations. And thank you all for joining us. Thank you, Salome and John, the 2 brand soldiers who work in the background. Asanteni sana.